If you die with a will, you have the right to appoint in your will who you want to be, in effect, your power of attorney when you die, who you want to be your executor. Okay? This person has the responsibility of marshaling all your assets, getting them all together in one place, and then selling whatever assets are necessary in order to pay all your debts and any bills that you may have, and then distributing the assets to the people who you want the assets distributed to. You get to pick who gets your property. Now, in New York State, we don't have forced heirship. So if you have 2 children and you want to leave your property to one of them, you can leave it to one. And as long as when you made out your will, you are of sound mind, the other child can contest it, because I can never tell you that he's never going to contest it, because you can always contest something, but they wouldn't win. They would file papers and the judge would dismiss it, because as long as you have sound mind, you have the right to dispose of your property as you please in New York State. The only one who has a right of heirship in New York State is a spouse. So if you're married, and this is interesting because most people think that if you're married, the spouse gets to inherit everything. That's not true. In New York State, if you're married, your spouse has the right to 1/3 of your estate. So if you have $300,000 and you decide to, and you're married, and you decide to leave the $300,000 to your child, and you die, your spouse would have the ability to file papers with the probate court in Westchester County. It's called a surrogate court in Westchester County, with the surrogate's court saying, hey, wait a second, I'm entitled to my 1/3. And the spouse would be entitled to 1/3 of $300,000 or $100,000. Other than the spouse, you have no legal obligation to leave your property to anybody. You can leave it all to charity, you can leave it all to a child, you can leave it to a friend, you can leave it to whoever you want. It's completely up to you. Now that's if you die with a will. If you die without a will, then New York State has a will for you, because we're not going to let you die without a will. So we decide who gets your property. It's called, you may have heard the term, it's called intestacy. So if you hear of somebody dying intestate, that means they died without a will. And what happens is, we've decided that if you die without a will, your spouse is going to get half your property and the kids are going to get the rest. If you die without a spouse, it's going to go to the kids. If you die without kids, it's going to go to the parents. So there's a whole listing of people. There's a hierarchy in the statute telling you who's going to get your property if you die without a will. Now, you may read that statute and say, you know something? I like who New York State has decided is going to get my property if I die without a will. But you may not like it, and that's the point. Most people don't like the will that New York State makes for them, so they make their own will. The other thing is, New York State will decide who becomes your executor. Now, they don't call it an executor. When you die without a will, they call it an administrator. But the judge and the state will decide who is going to be responsible for marshaling your assets, who's going to be responsible for paying your bills and distributing your assets. If you want to have control over that, it's very simple. You make a will. Now, a lot of times people don't make a will because they say, you know something, I'm not sure what I want to do. One of my kids is a teacher, married to somebody in the Peace Corps. They're not making a lot of money. The other one's a famous surgeon. He's making a lot of money. He's married to a high-powered lawyer, and they're doing very well. And if I leave half my estate to each one, then is it really fair because the other ones aren't making as much money? Then you get another person who says, well, I want to leave it 50-50 no matter what profession the kids have chosen. There's no right answer. And lawyers have a saying, well, what's equal isn't fair and what's fair isn't equal. So you don't know, okay? There's no right answer, there's no wrong answer here. It's whatever you're comfortable with. But if you don't make out a will, then the government's going to decide who gets the property. So a lot of benefits to having a will, and to simply say you don't want to do it because you're not sure of what you want to do doesn't make sense. Make a decision, and if you don't like it, tomorrow you make another one. You don't like that one, next week you make another one. Wills are what's called ambulatory. They don't take effect until you die. So if you make a will today and 6 months go by and you decide, you know something, I didn't get a card for Father's Day for my son and the other one always, it happens. I got to tell you, as a lawyer for 21 years now, it is it's really a disgrace what has happened to the American family. I can't remember the last time I met with clients where there wasn't something going on. This sister-in-law didn't talk to that one, or this one wasn't upset they didn't get invited to that, or Thanksgiving dinner. There's always something, and these are deep-rooted issues in families. So the last chance you have to express your wishes is in your last will and testament, and we see a lot of people putting in language in their wills saying, listen, you know that time you didn't do that? I was really upset about it, so therefore, instead of getting X, you're going to get Y. So if that stuff is...
Put that in the will?
Yes, you can put that in the will.
Yeah, but people do.
People do put it in the will. In fact, many lawyers say it's important to give you a reason. So if you have 3 kids and you're not going to leave it a third, many lawyers will say, put a reason in so that the child who's getting shortchanged, if you will, maybe won't even contest it because they'll have a better understanding of why you did what you did. Others say you're better off not putting anything in because you don't want to put lighter fluid on an already dicey situation. So again, it depends on which lawyer you're working with and what they're comfortable with. So this will can be changed as many times as you want, and what happens is when you die, the will gets admitted to probate. Now, many of you have probably heard the term probate, but maybe you haven't thought about what it means. Probate is a Latin term. It means to prove. So when you die, the only person in the world who knows that this is your last will, that you didn't make another one, is you, but you're dead. So we can't ask you. So if you had a will dated June 6, 2006, and you died on June 8th, 2006, how would we know you didn't make another will on June 7th? Nobody would know but you, because you could have gone to another lawyer, you could not have, maybe you didn't tell your wife about it, or whatever. You could have done it. So since we don't know whether or not you did it, and we can't ask you, then whoever has a will that they think is your last will, whoever's got that June 6th will, they go and hire a lawyer and file it with the court. They say, okay, we think this is Charlie's last will. And then you give notice to certain family members, and the law tells you who you got to give notice to, and they get a copy of the will. And they say, listen, Aunt Sally thinks that this is Charlie's last will, that he hasn't made a later will. If you know of a later will, or if you know of any reason why this will shouldn't be admitted to probate, well, because Charlie had end-stage Alzheimer's at the time he made it and he wasn't competent to make out a new will, that might be a reason. Or he was in a coma. I mean, so there are lots of reasons he wasn't in his right mind. So if you have a reason why we shouldn't admit this will to probate, or if you think there's a later will and you know where it is, come forth and tell us about it. And you get a few weeks to appear in front of a court and tell the judge your story. If nobody appears, then the last will that was submitted for probate is admitted to probate, and the assets are then marshaled and distributed to the heirs. Now, a lot of people ask, what does it cost to probate a will? A lot of people don't want to do wills because they're afraid of the cost of probate. I will tell you categorically, it costs more money to administer an estate when you die without a will than when you die with a will. Because what happens is the lawyers and the family members spend more time trying to gather information and organizing your affairs, and this time could have been spent on actually doing the probate work. So if you want to save your estate money, have a will. If you're concerned about the costs of probate, talk to your lawyer before you hire the lawyer. Find out what the fees are in advance. Most lawyers, if they can, will try to give you a flat fee to do the work. If there are contingencies beyond their control, they'll tell you what they are, and maybe they can give you a range of what it's going to cost. If you're not happy with the legal fee arrangement, talk to another lawyer. I mean, these things ought to be discussed up front. If you want quality representation, it's going to cost money. If you want to have a lawyer who does a little bit of the probate work, does a little bit of the real estate work, does a little bit of patent work, does a little matrimony work, okay, that's something to take into account in terms of how much of a specialist do you want to handle your affairs and how important is it to you. And that goes back to the original comment they made. Most people view this as something that's just a nuisance that they don't want to have to go through. But the truth is, every one of us in this room is going to have to deal with these issues. So that's what happens if you don't have a power of attorney. Even if you do have a power of attorney, you still need to have a will because you don't want to have to go through this intestacy proceeding in New York State. And the executor in your will is like your power of attorney. It's just that's the person who takes over after you pass away. Doesn't have to be the same person. The person who you appoint as power of attorney can be a different person than who you appoint as your executor. It's completely up to you.